matter of People versus Joshua Lanto. Mr. Lanto, can you hear me?
I can hear you.
Okay, Counselor, you want to put your appearance on record?
Looks like Mr. Cooch left the room, Judge.
Is he anywhere to be seen?
This is what he came out and went back in.
Okay. Mr. Greco, it's been indicated to me that somebody wants a 30-day adjournment on Mr. Lanto's case for discovery. Is that right?
I wasn't, that's fine with me, Judge, if that's what the request is.
Well, quick objection. The request was, why don't we just drop this right now?
Okay, Mr. Lanto, you understand that you're the one requesting that you be given 30 days to get this. It's not the prosecutor.
Well, the first thing I want. Okay,
you want a trial today? You want a trial today?
Well, I mean, I'd even be willing to, sign a guilty plea today if the court can just produce the factual evidence of jurisdiction. It should be in my file somewhere. I was asking for the same thing up in the Clarkston courthouse, and they send me to the Oakland County Jail.
Mr. Lanto, I'm not going to produce anything. I don't have to. I'm the judge. And as far as I know, the prosecutor can only produce what he wants to produce to convict. So we're not doing that. Your attorney's asked for 30 days. Do you want the 30 days or do you want to go to trial?
Well, let's see what the discovery evidence has to say. But first, if they could, very first thing out of there, they could send the factual evidence of jurisdiction. That would be great. It should be a one-page document. If the prosecutor filed it, fantastic.
Mr. Lanto, you're talking crazy. I would suggest that you listen to your attorney, okay? I'm going to adjourn this matter on his motion for 30 days.
Did you just say, can you
I'm going to send this to the assignment clerk. Mr. Lanto, you're not listening. See, that's why you get in trouble, because you like to talk and you think you know it all and you don't listen. I'm going to adjourn your case for 30 days. I'm going to send the matter down to the assignment clerk. She'll send out a notice. Hopefully your attorney will have the discovery that he wants by then, and we can handle your case. Okay?
Well, have you kind of calmed down a little bit?
What did he say? No. You're all set.
It seems like you were getting angry. It seems like you were getting angry.
No, Mr. Lanto, you can leave the meeting. We'll see you in 30 days or so. Clerk will send you a notice.
Well, I just want the record to show I've asked these same questions in several courts and nobody has said I'm talking crazy.
Oh, yeah?
That's the first time somebody said I've been anything but reasonable in a courtroom.
Huh. That's amazing.
Huh, right.
You're talking like you know all about the law, and it doesn't make any sense to me.
Well, then let me ask a few questions for clarification.
You don't need to ask any questions. We'll deal with it in 30 days, Mr. Lanto.
Wait, we can't ask simple logical questions today?
Ask your attorney when you see him.
Like I said, I'd be willing to sign the guilty plea and just, be done with this if I just see the factual evidence of jurisdiction, number one. And then number two,
asking for discovery.
Okay, and then the proof of jurisdiction is going to be in there? Is that, I'm asking a simple logical question. It's either yes or no, the proof is going to be in there or not. It's very simple. It's very logical, actually.
Well, let's see.
Mr. Lanto, I think maybe you ought to come into court in person next time. And your attorney will be here in person, and we can talk about it. So when you get that letter,
well,
can I put on there that he's in person? I'm going to indicate to the assignment clerk that I want you here in person. You know where the courthouse is?
Well, I feel like
Exactly.
I'd be in danger if I came there. I'd be in danger.
No, you won't be in any danger. I'll assign a policeman to watch over you.
That's the
Chris,
scariest
when
thing I
you
could
watch
ever
over
hear.
him when he comes.
Absolutely.
That is the scariest thing I could ever hear. And that's coming from a very reasonable person.
Okay, we'll see you in person in about 30 days, whatever date the assignment clerk gives you. And you come into court and we'll take care of business, okay?
So what does it mean to take care of business and I got to come in person and you're going to assign a police officer to me and then you said I'm talking crazy?
No, you got it
Did I
reversed.
just recall what was said on the record? Did I just recall that correctly?
No, you said it in reverse. I said first that you're talking some crazy talk. Then I said I'm going to adjourn it for 30 days. And then I said, because you're worried about it, that I'd have an officer watch over you while you're in court. We'll see you in 30 days.
Not every sovereign citizen confrontation ends in arrest, contempt charges, or a forensic evaluation. Sometimes it ends in something almost more frustrating. A polite adjournment, a patient judge, and a defendant who walks away genuinely convinced he made perfectly reasonable arguments. That is exactly what happened in the case of Joshua Lanto, appearing via video call for a pretrial hearing, and bringing with him one of the most recognizable demands in the sovereign citizen playbook. Prove to me that this court has jurisdiction over me. The setup was straightforward. Lanto's attorney had requested a 30-day adjournment to gather discovery material. The judge was ready to grant it. Simple, but Lanto jumped in with an objection. He said he would be willing, right then and there, to sign a guilty plea if only the court could first produce what he called factual evidence of jurisdiction. 1 page. That was all he said he needed. He had apparently made this same request in multiple courts before this one, and he was baffled that no one had ever simply handed him that document. The judge's response was clear and unambiguous. He told Lanto directly, "I don't have to produce anything. I am the judge." The prosecutor produces what he needs to produce to make his case. Jurisdiction is not a document sitting in a file waiting to be handed over. It is established by law, by the Constitution, by statutes, by the very structure of the court system. But Lanto could not let it go. He kept returning to the same point, framing it as a simple, logical question with a yes or no answer. Either the proof of jurisdiction is in the discovery materials or it is not, he said. It is very simple. It is very logical, actually. The judge, to his credit, kept his composure, though he did at one point tell Lanto plainly that he was talking crazy and that he needed to listen to his attorney. He told him to stop talking and let the professionals handle the next 30 days. When Lanto pushed further, the judge suggested that he come to court in person at the next hearing so they could have a proper conversation face to face. That is when things took a darkly comic turn. Lanto said that coming to court in person would put him in danger. The judge offered to assign a police officer to watch over him while he was in the building. Lanto's response? That was the scariest thing he had ever heard. What makes this case stand out from the others is its tone. There was no explosive confrontation, no contempt warning, no forensic evaluation ordered, just a quiet, circular conversation between a judge who had clearly seen this all before and a man who genuinely believed he was being entirely reasonable. And that, in a way, is the most revealing part. Because Lanto left that hearing convinced that he had asked simple logical questions that no court had ever been willing to answer honestly. He told the judge that no one had ever called him unreasonable before. He seemed genuinely surprised. That is the deepest trap of sovereign citizen thinking. It does not always feel extreme from the inside. It feels like clarity. It feels like asking obvious questions that the system refuses to answer. And that feeling of being the only reasonable person in a room full of people playing a game can be almost impossible to shake. But courts do not operate on feelings. They operate on law, and no amount of asking for a jurisdiction document is going to produce one, because that is simply not how the legal system works.